handout in your materials called CGAL Hypotheticals, Taking a Position on Children's Best Interests. And if you could just read hypothetical 1 while I'm getting set up, that would be great. And just look back up at me when you're done reading so that I know we have a critical mass. To be a discussion about what some considerations would look like in a real case. So it's really what I'm looking for is input from all of you on what you think the important factors are and how you would go about answering these questions that you would likely have to answer when you're representing a child in a custody guardian litem matter. So the first thing that you want to know is what facts affect your representation of Sean's best interests. Does anyone want to volunteer an important fact that you'd want to consider from this fact pattern? Yes.
Asthma.
Yeah, so Sean has asthma, and why is that important?
You need to make sure that he's got medical care with whichever parent he's living with, and also that the home situation won't trigger his asthma.
Sure. So you wanna make sure that whichever parent is providing for him can meet his medical needs, and that there's a safe home environment that's not going to exacerbate the asthma. What other important facts do we know? Yes.
There's physical discipline here, and you don't know to what extent.
Okay, so we know that there's some sort of physical discipline, and we don't know exactly what that physical discipline looks like, so there may be some more investigation. Other important facts? Yes.
There's a CPO against Ms. M, and I'd want to know whether there was a finding, whether it was a consent order, what exactly happened, what the allegations were, whether the child was present, those sorts of things.
Great. So it's important that there was a CPO, and I think you guys already talked about this, but if not, you probably will hear it by the end of the day, that CPO can affect the legal presumption, so that's really important. Any other major facts? Yes.
Marijuana may affect the child's asthma.
Okay, so there's alleged drug use. Yes.
Ms. M has been a primary caretaker throughout the child's life.
Great. So there's a question of continuity, since we know that Ms. M has been the primary caretaker. Yep.
The dad doesn't have a stable home.
Okay, so dad doesn't have a permanent residence. Okay, I think that we've covered most of the important factors, and you guys pointed out some good ones. One thing to think about as well is Sean's age, right? The best interest consideration might be different for a 6-year-old than it would be for a 15-year-old. And we also want to think about Mr. P's visits and the fact that Sean does have some sort of relationship with him.
Can I ask a question?
Yes.
Maybe controversial and inappropriate. So drug use, I guess I'm thinking perhaps there's a range, so marijuana use versus heroin, or is it all just like drugs are bad, marijuana is a controlled substance, there's a presumption against the parent who's using marijuana, or is it a more subtle consideration in that?
Sure. So if I think I'm understanding your question correctly, that how does drug use affect your consideration? And I mean, in terms of presumption, there's no legal presumption that kicks into effect because a parent does or does not use drugs. So it's really going to be a fact-specific determination. So Ryan talked a little bit about signs of drug use, but you may want to know, is this parent recreationally using marijuana on a weekend when the kids are with grandma, or are they getting high every day? And it may depend on the type of drug that they're using and how functional they are and what the child knows. It's really hard to say that there's a black and white line that a parent who uses drugs can't be a good parent to the child, because sometimes they can be. So that's really something that's important to draw out in your investigation.
Okay.
Yes?
I think another important fact is that, given all the factors you have up there, what each of the parties is asking for. Because I would have assumed, given the fact that the dad is actually asking for custody as opposed to visitation, and mom is asking very restricted.
Absolutely. So it really matters what the parties' positions are. If dad was asking for sole custody versus occasional visitation, you may have a very different position on whether you're going to support dad's request. Are there other things that you would want to know? Who would you want to speak with? What information would you want to continue gathering? We touched on it a little bit. But are there other things, other burning questions you have when you look at this fact pattern? Yeah.
I don't know if it was obvious and I missed it, but it was unclear to me whether the child had actually stayed overnight with the dad ever. It said he likes to take him to Chuck E. Cheese's. So maybe for a 6-year-old, a jump to staying a month with the father and on weekends would be a lot if they've never had any overnights.
Okay, so you want to know more about the length of the visitation that Sean has had with his dad. Does that visitation take place overnight? Where does it take place? Who else is present? Those are really good questions. Yes.
I mean, most obviously what Sean's subjective experience and preferences are with regard to Mr. P and program.
Sure. So Sean might be expressing preferences even at a young age. And generally, at 6 years old, we try not to ask, who do you want to live with? Or who, do you want to see your dad on the weekends? Because that can be really stressful for a child. But children of that age will often give indicators that they have a clear preference, that they feel really proud of the backpack that mom bought them, and they don't like when dad tries to take it away. There are ways to ascertain what the child's preference is, and that's really important. Are there any records that you would go about requesting to assist in your investigation?
Medical and school records.
Yeah. So medical and school records can be really valuable. Sometimes they don't say anything, but sometimes they will tell you a lot about have both parents been going to parent-teacher conferences? Have both parents been going to the doctor? Are there special needs that you're not aware of? Are there incidences that have happened at school that you don't know about? So those are really valuable, and also can be really important in presenting your case if you have to go to trial, which is a nice segue. I'm sorry to cut this short, and you guys can read Hypothetical 2 on your own if you'd like, and we encourage small discussions, but Marissa's going to come back and talk about presenting evidence if your case goes to trial. So, thanks everyone for your participation.
So again, I'm Marissa Gunn, and we're going to talk about presenting evidence. I'm going to move through this pretty quickly because we are scheduled to end at 3:30, and it's our hope to get you guys out of here on time. So if at all possible, I'd like to hold questions until the end. If there's time, I'm happy to answer them here, and then I can also stick around if people need to leave after 5 or right at 3:30. Others that still have questions can stay and ask. So the law of evidence in DC is largely based on case law. We do not have codified rules of evidence like the federal rules of evidence or other states that have adopted or modified rules like the federal rules of evidence. The DC Court of Appeals and the City Council have adopted certain individual rules, and then there's case law and statutes that largely track the federal rules in many respects, but generally speaking, you're not going to find a codified law or set of rules of evidence in the District of Columbia. One of the main sources of authority, though, is this Domestic Relations Rule 43, which generally says that the court is going to favor the reception of evidence. So if there's some question regarding admissibility, a real genuine question, the court's going to try and construe whatever rule you're looking at to make it such that the evidence is deemed admissible and considered for the purposes of the trial. So who's going to bear the burden of proof at trial? The plaintiff or both parties are going to have some burden, typically. You could have cross complaints, in which case both parties will essentially be putting on their own case. If you have one party that needs to rebut a presumption, whether or not they are the moving party or the party that's filed the complaint, they're still going to have to put on evidence to rebut that presumption for or against joint legal and physical custody. A party seeking to modify a final custody order or a motion for contempt, that person is going to be the moving party. And then the GAL would be expected to take a position based on the children's best interests and then put on evidence in support of that case. And it's important to remember that as the guardian ad litem, you are independent. So you're not required to, although you often will. You're not required necessarily to take a position that very closely aligns with one of the parties. In some cases you will. In some cases, you're really not going to align with either party. You'll have cases where both parents say, I should have sole legal and physical custody, and that person should never ever see this child. And they're both going to say that about each other, and you're going to say, actually, no one has any evidence to rebut the presumption, and there should just be joint legal and physical custody. That happens a fair amount of the time. Determining what the burden of proof is can depend on who the parties in the case are. So if the parties are two parents, then the burden is really going to be just showing by a preponderance of the evidence what is in the child's best interest based on the statutory factors. But if you have a third party versus a parent, that third party is first going to have to rebut the parental presumption that we've been talking about today, the presumption that it is in a child's best interest to be in the custody of a parent. And they have to rebut that presumption by clear and convincing evidence, which is much higher than the preponderance of the evidence standard. And this code section can tell you the ways in which a person can rebut the presumption in favor of parental custody. And once that hurdle is cleared, then they move on to the best interest factors, which again have to be proved by a preponderance of the evidence. Note that the best interest factors in the parent custody statute and the third party custody statute aren't exactly the same, but they do largely take into account the same kinds of information. And like Diane mentioned earlier, these are not exhaustive lists. The court should consider each one of those factors, but there may be other factors that the court should consider just based on the specific facts of the case that you're working in. So the role of the guardian ad litem leading up to and during trial is to take a position on the factual and legal issues that come up in the case. Your position can change during the course of the case. And that can be on smaller things. For example, your position on whether or not someone has committed an intra-family offense. That could change. One party says, oh, he punched me in the eye 3 years ago, and suddenly you think that's an intra-family offense. But perhaps upon further investigation, you think the person making the allegation isn't very credible, they claim that there was a CPO that doesn't exist or was dismissed or something like that. Your position on that can change as you gather more information about it. And then your position generally on what type of custody arrangement is in the child's best interest can change as well. You might favor one parent starting out and later favor another, or you may favor one parent primarily and then decide actually it's looking more and more like this is a case where joint legal and physical custody would be in the child's best interest. But it's important to remember that your position has to be based on the child's best interests. And then throughout the case, you'll be presenting and challenging evidence that's going to advance that position. And you'll do that through witnesses and through exhibits. So when are you presenting evidence as a custody guardian ad litem? First, you'll do it in pendente lite and other evidentiary hearings that typically happen before the point where you get to a trial on the actual custody matter. So during those hearings, the court could take testimony from the parties or other witnesses on more narrow issues such as a temporary visitation schedule during the pendency of the case, or whether or not the child should be called at a trial, on more discrete legal issues than the bigger question of custody. It's important to keep in mind that you may have a lot of status hearings in these cases, and at each of those status hearings, when the parties are present, they will be sworn in. So technically speaking, they may be giving testimony, but that doesn't mean that everything that happens at that hearing is sort of part of a trial record or an evidentiary record. So the party statements themselves certainly could come up again and can be used to either support their case or could be used against them at a later time. But for you as a guardian ad litem especially, just because you're standing before the judge and giving some sort of oral report about some testimony or information that could come out at trial, that information is not technically in the trial record. That's not part of any trial. You're going to have to reassert those facts and provide a witness or a document to actually get it into the trial record. So when we're talking about this, evidence taking prior to trial, we're not really talking about the status hearing. We're talking specifically about evidentiary hearings. And you should know, based on the language that the court uses at the close of a hearing, when something is scheduled, the way that it's listed in a scheduling order, you should be able to tell whether or not it's evidentiary in nature. A motions hearing is usually evidentiary in nature. PL hearings, pendente lite hearings are evidentiary in nature. Status hearings typically are not. And then the other place where you present evidence is at trial. And remember that the guardian ad litem has the right of a party. So you'll put on your own case, just as Judge Krauthammer mentioned. The plaintiff usually goes first. They'll call all of their witnesses. the defendant will be able to cross-examine those witnesses. Then the defendant will go, put on their witnesses, plaintiff can cross, and then the guardian ad litem will have their opportunity to call their own witnesses. It could include the parties. You might decide not to call the parties and just cross-examine them in their own cases, but you are able and do have the opportunity to put on your own case. So there can be issues that need to be resolved prior to trial, and typically to get those resolutions, you'll do that by filing motions and recipes. So you might do a motion for a psychological evaluation, a motion for visitation, or to provide the court with information. You might file a precipice with the child's report card attached. This came up a little bit earlier that the Children's Law Center, we prefer a motions-based practice over a report, a practice based on reports for a variety of reasons that some of them have come up already. But something to keep in mind is that there is no way to respond to a report, right? So if you file a report and then make a recommendation, there's not a clear way for a party to come in and say that they disagree with you, but they have the right to do that. So it's just it's a lot cleaner. It's easier for you to create a clean record if you do things through motions, and then people can file responses, oppositions. You can have an evidentiary hearing, and then it's very clear what's happening, and the court will have to articulate, this is the evidence that I've received. This is the way that I have sort of ruled based on that evidence, and this is the determination. Yeah.
Quick question. Why would you want the court to see the kid's report card just on its own outside of a motion?
Well, sometimes the court will just want that information and request it.
Oh,
Other times, you know, perhaps someone has filed a motion and alleged something about the child's education that's not true, and that's very clearly shown by the report card. A lot of times the GAL would attach a report card to a report, and then include a lot of other information that is sort of filtered through the GAL and the GAL's position. If you do it this way, the document stands alone. Again, it's being provided to the court and the court can look at it, but it's not in evidence yet. So if you really want to use this as the basis for an argument, you'll have to wait until you have your trial or your evidentiary hearing. You're either going to have the parties stipulate to the authenticity of that document so that the court can take it as a true and accurate document, or you're going to call a records custodian or a teacher from the school to authenticate the document. Remember that there is a bar on ex parte communications, and we've cited a couple rules and standards here for you to refer to. Generally, any communication that you have with the judge or the judge's clerk that is going to in some way give you an advantage over another party, that's going to be considered an ex parte communication. If it's really about an administrative issue, you know, confirming the date and time of a hearing or something like that, those really aren't ex parte, but a lot of times, particularly where the parties are represented, even when it is just administrative, it's a lot easier to just go ahead and copy the parties on any communications. Obviously, you're not going to do a phone conference every time you have a question, but the judge's clerks do have emails, and you would get that email address with the referral information that we send you. So that's the way that you could reach out to the court when appropriate. As I mentioned before, we do prefer a motions-based practice. You are an attorney in the case. Guardians ad litem in DC are required to be attorneys, and that's not the case in every single jurisdiction. But as attorneys, we're required to present cases the way any other attorney would, and that's by presenting evidence. Again, reports are not evidence, so that's another reason why we prefer motions. Reports can be prejudicial. A lot of times the guardian ad litem will end up making a lot of factual proffers, and oftentimes those are proffers based on information received from reliable sources like therapists or school personnel. But nonetheless, when it comes in the form of a motion, you're not actually putting the evidence in the record the way that you would at a trial or an evidentiary hearing. So once that information is followed by something like a recommendation or a proposed order, you do run the risk that the court is going to give it more weight than it would give a similar request if it came from another party. And that's not really the way the judicial system is meant or intended to work. And keep in mind that the GAL cannot be an advocate and a witness in the same proceeding. And if you're not very careful about the way that you draft these GAL reports, you can run the risk of making yourself a witness in the case. But if you do decide to file a report, it's helpful if you just make sure that you consult the GAL practice standards, which do address the issues raised about filing reports, such as the GAL making themselves witnesses and running the risk of the court improperly considering information that's been presented in the form of report for the purposes of making a final determination after trial. And we would encourage you to reach out to the Children's Law Center, either if you're considering filing a report or if you're ordered by one of the judges to file a report and you're not really sure what to sort of make of that request. Just a couple of quick tips to avoid becoming a witness. You should request, update, and utilize records concerning the child. So, rather than summarizing in the form of a report what you saw in medical records or educational records, it's better just to provide the record itself if that's what you're going to be using.
As a business record?
When it comes in at trial, yes. Typically it will come in as a business record. Sometimes the medical records will come in, hearsay contained within them, which would otherwise need to be redacted, can come in for, purposes of treatment, all those sorts of things. But typically, yes. Once you get to the trial stage, it would come in as a business record. When you're going on home visits and other sort of visits involving clients, it's helpful to take a third party with you. And that should be someone who could be a credible witness for you at trial and someone who is not appointed to the case or is not going to be too closely affiliated with you, such that they could be viewed as someone being appointed to the case. So that person is going to be able to say, yes, I was present when the GAL did this home visit, and then describe the home. Because you as the guardian ad litem, you can't take the stand and describe the home, because that would be making you a witness in the case. You also can't talk about, statements that one of the parties made. Although the parties could introduce those statements as a statement of a party opponent, you can't be the person to introduce those statements yourself. And you also want to interview and regularly check in with disinterested and otherwise reliable people, like teachers, neighbors, other family members, potentially social workers. Those are all people that are generally considered reliable. A lot of times they are not more or less closely aligned with one or another party in the case. Sometimes they are, and you'll need to be mindful of that. You'll have cases where, for example, a child has been in the primary custody of one parent for several years, and then that child has something called a community support worker. If that community support worker has only had contact with one parent, although they may not be saying negative things about the other parent, they really don't have anything to say at all about the other parent. So it's hard for them to be sort of truly objective because they don't have a basis of knowledge for the other person. So it's important to keep in mind whether or not some of these folks are actually neutral. It doesn't mean that they're not going to be valuable to you, but just keep in mind when you're sort of assessing what information that they can provide and whether or not it's going to be valuable to the court. Discovery. So discovery is governed by Domestic Relations Rules 26 through 37. I think this came up before, but yes, guardian ad litems can serve and may be served with discovery. It's not very often that we decide to use discovery in these cases. As has already come up several times, many of the parties in these cases are pro se. They don't necessarily have the time and the resources to really understand and respond to a lot of discovery requests. But sometimes there is counsel on cases, and at times, even when people are represented and they serve discovery, a lot of times they won't serve it on the guardian ad litem, but sometimes they do. So we would just suggest that you contact one of the mentors if you have questions about, if you're considering serving discovery, or if you're served with discovery requests yourself and you're wondering how to respond to them, because things like, confidentiality are going to come up when you're responding to discovery requests. Feel free to call us so we can talk through some of those issues. And also refer to the CGAL, the practice standards, specifically the paragraph on confidentiality of communications.